Hello and welcome to a recap of our February 13, 2026 newsletter. We hope you had a nice Valentine's Day weekend and are looking forward to a Mardi Gras this coming week, and to more news about trademarks, franchises, and other legal stuff, and some trivia. Like I said, this is a recap of our February 13 newsletter, where we discussed whether you like your perfume to smell like roses, sandalwood, or infringement, otherwise known as the Estée Lauder trademark case against Walmart. We also talked about the new lawsuit against the Cadillac F1 team over whether the team had stolen someone's idea for its Super Bowl commercial and what that has to do with Bob Loblaw from Arrested Development. We also answered a frequently asked question about why my trademark needs to be distinctive. And we had some trivia, which you can see at the end of this video. I'm Tom Vanderbloemen. I'm a lawyer in South Carolina. Our firm handles trademark and franchise law, as well as other patent, copyright, and business matters. If you like this kind of thing, please like and subscribe, and also sign up for our newsletter in the link in the description. Do you like your perfume to smell like roses, sandalwood, or infringement? Estée Lauder has been around for a while. It's been selling beauty products and perfume for decades. Mrs. Lauder's story is actually quite interesting. She was born in 1908. She learned to make skin creams from her uncle, who was a chemist and had lived with them. And she started the company in the 1940s, with her first major order being an $800 order from Saks Fifth Avenue. Now, Estée Lauder is actually a family of companies, and they have numerous trademark filings, including for the Estée Lauder trademark brands, and also for MAC, Clinique, Tom Ford, and others. But you don't have to go to Saks Fifth Avenue to buy Estée Lauder products anymore. You can get them from Walmart. Or can you? This past week, Estée Lauder sued Walmart for trademark infringement, claiming that some of the products being sold through Walmart's online platform were knockoffs. Apparently, some of the products that Walmart sells online are filled by third parties. While Walmart may monitor those third parties, Estée Lauder says that the monitoring is not enough because the knockoffs are still being sold. The complaint claims that some products are actually labeled with Estée Lauder, Clinique, Le Labo, and other trademarks that are just not genuine. Estée Lauder also provided examples of some products using names and packaging that are very closely similar to some of its company's brands, like Picky Rose instead of Rose Prick, and Cherry Buzz instead of Electric Cherry. Estée Lauder may be anticipating that Walmart will try to separate itself from the third parties that sell these kinds of products on the platform. This is sometimes an issue with online platforms. A while back, there were claims that eBay was not sufficiently monitoring the sale of counterfeits on its platform. Now, the platforms will want to say that they can't catch all the knockoffs, and therefore they shouldn't be responsible for what some third parties are doing as long as the platform is taking reasonable steps to monitor what's going on. Now, maybe anticipating this argument, Estée Lauder cited a prior similar case that Vans, Vans, the skater shoe clothing company, a similar case that Vans brought against Walmart. There, a court explained that from a Walmart.com user's perspective, the separation between the third-party sellers and Walmart wasn't really as evident as maybe Walmart thought it might be. Now, the court did dismiss some parts of Vans' case, but allowed other claims to go forward toward trial, and shortly after that, it appears that Vans and Walmart reached a settlement. So we'll see if that happens in this case involving Estée Lauder. For now, even if Valentine's Day may be over as we record this, Walmart.com may still have some last-minute deals on perfume. Did the F1 Cadillac team steal someone's idea for a Super Bowl commercial, and what does this have to do with Bob Loblaw from Arrested Development? Ron Howard directed some of the great movies of our time, including Apollo 13, but one of his earlier jobs was a movie called Night Shift, starring Michael Keaton. Now, why bring this up? Michael Keaton's character was a self-proclaimed idea man. He came up with all these crazy ideas, and he would record them into a tape recorder so he didn't forget them. One of his ideas was to eliminate garbage with edible paper, or to save a step for people making sandwiches by feeding mayonnaise to tuna while it was still alive. But can you sue someone for stealing your ideas? This is the issue in a recent case brought by Michael Bay against the new Formula One Cadillac team. Bay, who you may remember from films like Transformers and Armageddon, films he directed, he claims that the Cadillac team stole his ideas for the Super Bowl commercial. Cadillac's team is new to F1 this year, and they debuted their new car in their livery, as they call it, during the commercial. According to The Athletic, which obtained a copy of the lawsuit, Bay claims that he was courted by the team to direct their commercial. Bay claims he discussed the project with the team and began working on it, even believed he'd been hired. Now he's seeking $1.5 million as well as punitive damages. So why mention this case? In the intellectual property world, that's the area of law protecting patents, trademarks, copyrights, and trade secrets, we often talk about protecting ideas, but Michael Bay's case doesn't appear to mention these traditional areas of patents, trademarks, copyrights, or trade secrets. Instead, it looks like he's suing for breach of contract, including what they call an implied in-fact contract, which is when you don't really have a contract, but you kind of act like you do. He's also suing for fraud. So what's the difference between those kind of claims and traditional patent, trademark, copyright, trade secret claims? Well, patents apply to new and useful inventions, and in a sense they do protect the idea of the invention, but there's a whole process for obtaining an issued patent from the government. And the idea itself has to be the kind of things that patents even protect. We sometimes call that patentable subject matter. Patents don't cover every kind of thing. They don't cover every kind of possible idea. I'm not sure if they would cover feeding mayonnaise to tuna fish, but you get the idea. The point is that patents do cover certain new and useful inventions, but not every new idea. Trademarks usually focus on preventing confusion among brands. There may be some ideas about those brands and concepts that those brands demonstrate, but trademark law is really about protecting brands. Copyrights don't protect ideas really either. Instead, they protect the expression of the idea, what you might find in books or movies or artwork or photographs. Trade secrets, which are really the last category of traditional IP protection, can theoretically protect ideas, but they generally need to have been kept confidential and have value by not being known to competitors. Michael Bay's claims in this case likely rely on a different kind of theory, that he shared his ideas after being led to believe he'd been hired, sort of as though he was induced into sharing his ideas in reliance on the idea that he'd been hired for the job. It doesn't sound like there was any kind of written agreement, like a non-disclosure agreement or an NDA, as you sometimes hear it called, but that doesn't necessarily prevent the claims, since not all contracts have to be written down. Now, there is a pro tip here as we come out of Valentine's Day. Some contracts do need to be written down, like any agreement made upon consideration of marriage. That's a quote from South Carolina's Statute of Frauds. So keep that in mind in case you came out of Valentine's Day with some questionable commitments. So why mention Bob Loblaw? There are a few connections here, so just bear with me. Michael Keaton. In the movie Night Shift, his co-star was Henry Winkler. Some of you know Henry Winkler from his original claim to fame as being the Fonz on Happy Days, the TV show that ran in the 1970s and 80s. However, we're partial to Henry Winkler's role as Barry Zuckerkorn, the Bluth family lawyer in Arrested Development. It was Scott Baio who played the Fonz's cousin on Happy Days, and who, in a not-so-subtle reference to Happy Days, then replaced him as the second Bluth family lawyer in Arrested Development. His name was Bob Loblaw, and he had a law blog. You can see a link to one of his commercials in the newsletter. So who narrated Arrested Development? Well, that was Ron Howard, also who was on Happy Days, and who was also the director of Night Shift. That brings us full circle. It's a little bit of a long path to get there, but it gives you an idea of the kind of things we like. What is a distinctive trademark, and why should I care about whether my trademark is distinctive? Trademarks are sometimes called source identifiers, which is a weird way of saying it, but what it really means is that they identify who makes the product or who offers the service. So a shoe with, let's take for example, the word Adidas on it. You can see Adidas back here too. A shoe with this on it, or that well-known symbol that you see for Adidas, lets people know that this shoe comes from Adidas, a particular source, or at least from someone who's authorized to make Adidas merchandise. Now, to serve the purpose of a trademark, that means the trademark has to be distinctive enough that a consumer who sees it would think, oh, that's a brand that belongs to one company, as opposed to a merely descriptive term or a generic term. Because if this shoe just simply said soccer shoe on it, then it could come from anywhere, and consumers may not necessarily associate that with one particular company. So context also matters here, because some terms that may be generic or merely descriptive in one context could actually be somewhat arbitrary in another context. Take, for example, Apple or BlackBerry. Before computers were called Apple and before mobile phones had been called Blackberries, if anyone still used them, at that time they were fruit. And so it would be generic to use BlackBerry or Apple to refer to fruit that you were selling. But if you're selling a computer or a mobile phone, those terms are arbitrary, as we call them, which means they're distinctive and they can function as trademarks. Courts sometimes think about these things on a spectrum. On the one side, you have terms that are generic, and generic terms really can't ever function as trademarks. They would be like soccer shoe. On the other end, you have arbitrary terms, like I mentioned, for Apple for computers or BlackBerry for mobile phones. You also have what are sometimes called fanciful or coined phrases, made-up phrases like Xerox or Kodak. In the middle of that spectrum, you have suggestive marks and you have descriptive marks. A suggestive mark is something, like it sounds, it suggests or calls to mind certain features of a product or service, even if the term doesn't explicitly tell you what it is. Think like Netflix as a good example. Netflix suggests there's something about movies and something about online or the computer. It's a suggestive mark, and it's considered distinctive from the outset and can function as a trademark. A descriptive term, however, it just merely describes what the product is or does or features of the product. A common example you sometimes see is cold and creamy. That phrase, cold and creamy, for ice cream really wouldn't function as a trademark because many businesses in the ice cream business might call their products cold and creamy or refer to them as cold and creamy. That said, over time, a descriptive term can acquire distinctiveness. Think about terms and trademarks like American Airlines or Bank of America. Now, at first, those would be pretty descriptive terms, a bank in America, an airline that's American. But over time, due to long-time use and exposure, those terms have acquired distinctiveness, and now consumers understand they identify a particular business. Now, obviously, the line between a suggestive and a descriptive trademark can be blurry, and some marketers kind of like descriptive terms precisely because they tell the customer what the product and service is without the need for extra advertising. And sometimes there's a need to get domain names or keyword advertising where marketers like to use those kind of descriptive terms because they know that's what customers are going to be typing into the search engines. But for the same reasons, descriptive terms are often harder to protect because so many people use them. In fact, sometimes with taglines or catchphrases, people want to claim these as trademarks, but they run into these questions and issues of descriptiveness. Sometimes a tagline or a catchphrase is just too descriptive and not trademarky enough to identify a source. This is a common misunderstanding, and just because you file an application for a word or a phrase that someone else may not have filed yet doesn't mean it can actually function as a trademark. Now, there are still often some very good reasons to file a trademark application, even if the term you want to file is close to that descriptive or generic line. One particular reason is defensive. Because if you can get a term registered or that phrase registered as a trademark and maintain the registration, it can be a helpful defense if someone later claims that you're not allowed to use that term. And sometimes, since it's debatable whether a term is sufficiently distinctive because it's suggestive or arbitrary or fanciful, or whether it's merely descriptive or generic, because that issue can be debatable, it may be just as well to file something and see how it turns out. But all this is to say that it's important to understand that if the term you want to register, even if it seems available or not taken by somebody else, still needs to be distinctive enough to serve the purpose of a trademark, which is to identify the source of the goods and services that bear that trademark. Let's turn to our trivia question from our most recent newsletter. This trivia question has to do with a trademark that was filed in the 1940s. And may derive from slang for general purpose modes of transportation. As far as we know, the trademark owner does not have any filings related to rubber ducks, even though rubber ducks are now often displayed by the vehicle's owners, and ducking has become somewhat of a tradition with them. What is this trademark? Send us an email if you think you know. If you like this kind of thing, trademark and franchise law, copyrights, patents, and other legal stuff, or maybe if you don't like those kind of things, but you just like trivia and you like to see regular pictures of our canine law clerk, you can like and subscribe, and you can also sign up for our newsletter in the link in the description. We hope you enjoy.